Moving on to our next question, and they want to know, how do you decide whether or not you're going to actually take someone's case, and what happens after that? That's a fair question. What is your barometer?
Go ahead. When I'll take that.
We decide if we're going to have a case based upon whether we think there is a legal cause of action and sufficient damages that make it worth our time and effort and their out-of-pocket expenditures in pursuing the claim. So once we decide that those thresholds have been met, then at that point in time, we begin by sending out notice letters to the insurance companies, inquiring into the amount of coverages, what their position is, et cetera. And we simultaneously undertake an investigation to see what the case is about. Now, if it's a wreck case where you've got the accident report immediately, probably in front of you, put all the uninsured motorist carriers on notice, which is a very critical thing that a lot of people miss out on. Carl, you may want to talk toward that, but that's something that's got to be done as soon as reasonably possible. If you don't do it, you don't avail yourself of that coverage.
Let me just give you a little more succinct answer to that. And I think what he's saying is that it really depends upon whether there's liability, whether there were damages done, and whether those damages were directly resulted from the negligence of the other party. Then everything else is how serious are the injuries or how serious is the case. Every now and then we will take a case that we can't justify on the basis of our time input, but it's just one of those cases that, again, in the parlance of trial lawyers, it just ought to or need to be sued. I sued a dry cleaners one time for misdyeing a lady's shoes to match her dress. We didn't get any money out of it, but we got a lot of satisfaction out of it. So sometimes you take cases that don't necessarily warrant the time and the expense of proceeding, but you do it anyway.
Okay.
So, again, always talk to a lawyer. Most
That's
lawyers
important.
will tell you exactly the way they look at it.
Okay.
What I was referring to on the notice to the client's uninsured motorist carrier is if you go back and look at their contract of insurance with their insurance carrier, there's a clause in there that says if you have an uninsured motorist claim or intend to bring one, then you have a duty as the insured to put them on notice as soon as it's reasonably possible. And the Court of Appeals has said 3 months was too long. So if you've been involved in a car wreck, you better put your insurance company on notice, even though it was not your fault. It's not going to affect your premiums, but you need to do what they contend is a prerequisite to bring in a claim for uninsured motorist coverage.